the amount of litigation really just about what happened in a mediation is expanding sort of exponentially. So building blocks or not, it's important stuff, and I think this will be a helpful reminder to everybody of things to think about as they're planning or conducting or participating in a mediation.
Is littered with different disputes that came out of mediation where one party thought that they had an agreement and another party didn't think they had an agreement, and that started us off with thinking, well, geez, mediation's always pushing to get common place, common ground. How does that happen? And it happens with an oral agreement. And the problem we noticed is that there's really three big policy pushes towards settlement at mediation that pushes folks to believe that an oral agreement, that they've actually settled it. So the recognition that mediation is challenging, but its goals are worthy in a civil society, that a final settlement document to resolve litigation as well. And then, of course, there's your mediator who wants to be successful. The mediators are trying to push the parties together, and you're trying to reach success. And on the other side are just a whole group of state laws which basically say, unless you have a settlement agreement, then communications are not admissible for mediation. There's a certain role that mediation plays, and those discussions are not entitled to be introduced into evidence, and the local banker objective manifestation of intent to be bound, then you can have an agreement, and you have to be very careful. That always defers to state law. State law governs, and it's traditional contract law principles in a meeting of the minds. Parties are free to contract. It's an objective manifestation of intent, and it parallels the values of mediation, which is basically self-determination. Can parties sit down together and reach an agreement? And even if there is an agreement found at mediation and it's not signed, and counsel say that there's a Third Circuit case that we cite in our handout that says, and it's the Norwood case and the Freeing case, that an agreement was binding even though the parties intended to adopt a formal document with additional terms at a later date. And that, to me, is a shot across everyone's bow that, you can have a disagreement then about what people think about what's more formal or what's a material term or what's a later date. And if you walk out of there and you have an oral agreement, and there is an open issue, Judy, why don't you talk a little bit about what you found in some of the state courts, about this whole issue of oral agreements and intent.
Well, I found that most of the rules in the bankruptcy world and the model rules that we use in our bankruptcy world all contemplate written. The party has to leave early and the attorney signs. That's not valid. It has to be signed by the party. So, everything I see contemplates written agreements, and they intend to be bound, and they sign it, and it's simple, and that gets the job done. But the form of settlement agreement is going to vary depending on certainly the attorneys for the parties and what they want to see in there, the complexity of the issues that you're dealing with, how many different parties you have, and what the actual issues themselves are. In simple mediations, we can go for a term sheet. In more complex mediations, we're going to need a comprehensive settlement. And then that raises the issue of, if we're in a very complex mediation, complex issues, do we can go on forever? I talked about a case I had in Florida in April that I continued and continued and continued while they worked on the agreement, and they finally couldn't get an agreement and declared an impasse. So there's got to be a better way to manage it in those real difficult, complex cases, because it sure didn't work there. When we have multiple mediations, or before I get to that, I'll say that some commentators urge the parties the attorneys for the parties to prepare settlement agreements ahead as part of their preparation and understanding of the issues. Some of the commentators also urge the mediator to require that be submitted. I think in a complex case, I have a hard enough time getting a really good statement of the issues and the confidential materials out of them. I doubt I would ever get, in a complex case, a settlement agreement. But what I can do when I do multiple mediations, and a lot of us do those where we're called in to do, 5 to 25 preference cases, and they're all the adversaries are arising from the same case, so there's a lot of commonality. Sometimes I will put together a form, a settlement agreement form with lots of blanks in it, and I will send it to all the attorneys and say, you two attorneys in each case, turn this into a form that you find acceptable and bring it to you. And I find when I've got a short amount of time and I want every mediation to result in a written agreement, that's the best way to get it done. And I think Derek had a few different ideas about that. And Derek, you're also going to talk to us a little bit more about the settlement agreement when we've got to put together the full settlement agreement.
Sure. So, look, it seems to me that in either of the oral agreement or term sheet agreement approaches, I mean, candidly, in my experience, the term sheet approach is what most often prevails. The problem with those is if you get to that oral agreement or a term sheet where there are certain material provisions that are well defined and highlighted and people understand what they are, that's great. But if then you're unable to get to the next step of a fully documented settlement agreement, it's unclear, whether you're ever going to get to those other terms. And the problem is, in this environment, it's not like the Uniform Commercial Code where, they've got some gap fillers. If your contract doesn't say this, then here's the rule. We don't have that. And, one key example to that might be the release provisions, which of course are critical to almost every litigant in a mediation. And most of the term sheets I see say standard form of release, period, or words to that effect. And the problem is we're going to talk about what it takes to get to agreement for a binding settlement here in a little bit. But if you haven't spelled out all the terms in a way that you're comfortable with, you can be left with a settlement that is sort of half-baked. It only includes certain of the terms that you want. Ideally, everybody's going to put the material terms into their term sheet, but it doesn't always happen that way, so you've got to be very careful. The gold standard, of course, is to try to show up either, as Judy said, by asking the lawyers to confer in advance and leave some blanks. Sometimes the mediators will do that. My experience in mediation is often mediating preference campaigns where there's a common plaintiff with, as Judy said, 525, 125 preference actions, and fortunately, in most of those cases, the matters that ultimately get to mediation typically come after some of these things have been fully settled. So it's not unusual at the start of one of those sort of campaigns in mediation to have a full-blown settlement agreement that they've sort of negotiated with a number of previously settled defendants that's pretty well fleshed out and has most of the bells and whistles you need. It is important if you have the time, and that's really where the rubber meets the road, to try to get as much done on a full-blown settlement agreement as you can. And as Judy suggested, it may make sense from time to time to actually continue the mediation so it's not over until people have sort of gotten as much on paper as they need to get on paper, circulated it, agreed on it, and signed it, because everybody's much better protected if they know exactly what the agreement says and all the terms are there, rather than potentially being stuck in a later piece of litigation with only half of your settlement agreed to.
Right, and that's,
the other thing. I'm sorry, Jeff. Jump in.
No. I just think, I mean, nobody wants, right to what you're saying, Derek. Nobody wants to invite the court into finish the negotiations of a mediation or determine what's material and what's not material. So it sounds like you're talking about that horrible in between where you have a nice clean term sheet that might have the terms, or you have a full formal settlement agreement and something that tries to kind of to bridge those two, which just leads to litigation.
Exactly, and you don't want to. Go ahead, Jeff. Sorry.
Yeah, and the state courts don't want it. I mean, that's from my review of the different state court statutes that govern mediation rules. They are almost unanimous in saying you don't have a settlement agreement, and unless it's in writing and it's signed and it meets these different rules, and some of them even say, you know, you have to put this in writing within 72 hours after you go to mediation, which all, you know, led me to believe that the state courts just don't want to play this role of trying to take a crystal ball out and figure out what the parties didn't figure out for themselves at the end of mediation.
Yeah, I think that's right. And the time requirement is a pretty key element. Most mediations that I've experienced, and I certainly do most of them in Delaware, but even other places, are generally done according to some legal framework, whether it's a statute or a set of court rules or a set of agreed mediation rules that are prevalent in a jurisdiction. And most of those do have pretty firm time requirements, particularly for reporting to the court. And as Judy talked about earlier, you don't want to be in that mediation that never ends and it takes 5 months to get to a settlement agreement. So the more discipline that you can apply going into a mediation, having forms available, suggesting people use existing forms, and getting it done crisply, the better off everybody's going to be and help you avoid sort of winding up fighting about what your settlement actually really means. Judy, do you want to talk a little bit about what the actual requirements are for a binding settlement?
Yeah, this is an important part. We've got, you can see on the slide, the first two are really the part. We've got to have the intent to be bound, and then we've got to have agreement on the essential terms. So I'm going to talk about those two things first quickly. There's case law out there where people have gone to court and said, well, we had these negotiations and we said we were going to write it all down in the future, so we really had an agreement, and that doesn't fly. And an agreement to agree, if we don't have an intent that says we've agreed to this much now, if we don't have the intent that what we have done now constitutes an agreement, a settlement, then we don't have a binding settlement. Likewise, it is acceptable to do less than a full agreement and say these are the terms and we agree to all these terms and we're going to write them up nice and fancy later. The fact that you're going to draft a more formal document does not mean that you don't have a binding settlement agreement. And both of those issues have been litigated. What's important is you have to have a mutual manifestation of assent to what's going on. And one of the really great cases, if you want to read about this, is a Third Circuit case called American Eagle Outfitters that's listed in your materials. So the key is not the extent to which it's in writing, but with intent, it's the extent to which the parties have agreed to those essential terms and have evidenced their intent to be bound. So they want to be bound to something. They have an intention. Is what they're being bound to good enough? And that's the second carrot on our slide. You can decide you want to be bound, but if you haven't put enough in there, if you don't have all the essential terms, then it's not going to be enforceable. So the nature and extent of the obligation that people are consenting to has to be clear. All the material and necessary details have to be in there. From a court's perspective, the court is going to look at whether the terms that are in that agreement are sufficiently definite that a court would be able to specifically enforce them. So it comes down to a question of law. There's an interesting tension in the Third Circuit between the American Eagle case and another case. American Eagle case found a settlement agreement binding, even though some of the terms were ambiguous. It had the intent, it had all the terms, but a few things were a little fuzzy, and the court said that they would simply remand it to the trial court to determine the meaning of the ambiguous clause. Now, if the whole thing is ambiguous and fuzzy, and it's not something that we can find a way, the court can't find a way to specifically enforce, then you're not going to have an enforceable contract. So you have to get all the essential terms in, you have to be clear in your language, and you have to evidence your intent to be bound. But you can say, and we're going to do something fancier later down the road. So let's talk now about what would be sufficient in terms of the definite terms, the essential terms that we need in here. And Jeff, I think you've got some comments on that.
Yeah, thank you. So, we talked about it's well established that that evidence of preliminary negotiations or a general agreement to enter a binding contract in the future fails as an enforceable contract, because the courts are looking to see if there is an intent to come to an agreement on the terms then and there, such that there's something there for the court to enforce. And that Shell disposal case that's on the handout, which talks about a contract fails for indefiniteness, when it's impossible to understand what the parties agreed to, because either A, the essential terms are ambiguous, or B, they're just poorly defined. So to me, that's one issue. Is there sufficient definite terms that a judge sitting there can say, hey, I can see what the parties agreed to. I don't have to participate in this mediation. I can just enforce what was done at this mediation. Then the other issue that jumps out to me, and it always jumps out to me as a litigator, is even if there are material terms and they're defined, is there something in the agreement that lets any third party or court know that the parties actually were concluding the litigation that day, and that these other issues that are always come up and that lawyers can always get in an argument about or have a disagreement about, whether those are just small issues, those aren't material or definite terms. And I just went back and looked through some of the mediation settlements that I had signed over the years when I was either a plaintiff and defendant. And then another one said, subject to being finalized. The third was to be followed by a formal agreement. And then the fourth one is, no settlement is final without a fully executed agreement. To me, the first one just raises a lot of issues. And as you progress through, they get stronger and stronger about telling a third party whether or not you got a deal or you don't have a deal. Then there's one mediator's agreement from a retired judge that I thought was done really well, and can basically lets you know that when you walk into a mediation, you can control your own destiny. If you got a deal and you want to make sure there's a deal, then by all means, a mediator frequently does this, but you can insist and put things in the language, in the term sheet. And this particular disclosure I'm going to read you right now just demonstrated to me after we started, or any party pursuant to CCP 664.6, which is our offer to compromise statute. This stipulation for settlement is also admissible in federal court and enforceable according to all federal rules of civil procedure, local rules of bankruptcy, and district court rules which in this litigation is pending. So I just thought, wow, that's a great paragraph. A, it says, here's intent to be bound. B, here's, what the party's material points are below this, paragraph. C, guess what? There's state statutes and we'll talk about this a little later when we talk about whether or not you have a creature which it's mixed with federal causes of action and state causes of action. But this paragraph says, look, if there's state causes of action or if there's federal
parties that sign a document that has words like that. We as lawyers are often always looking to preserve optionality and make sure that we've left open an argument or an angle. And when you put a settlement statement together that has language like Jeff says, it makes it clear to everybody what's going on. But it sometimes is a challenge at the end of a mediation when parties and lawyers are thinking about how they're going to get the plane to the train to get home, etc. So think about it. As a mediator, I love the idea. A little hard to implement sometimes because people say, oh, I need to think about this and want to look at the language again. But it really does, I think, serve you well if you can get that into your documents or get the parties to agree to it. Judy?
I would just like to leave with one thought from restatement of contract. When you're looking at your contract terms that you've put in and you're trying to decide if they're clear enough or whether they're vague or ambiguous, think back to restatement, which says the only reason certainty of terms is important is because it needs to be a basis for the court to determine whether there's been a breach. So if you look at those terms, if someone doesn't do it, is it clear that they didn't do it? Or have I not written the expectation clearly enough? So just that's a parting thought that I will now take us to a really difficult and hopefully not too lengthy section. We want to talk about what happens when there are third parties who are affected by the discussion in the mediation and impacted by the settlement agreement. So, Jeff and Derek, I think, Derek, you were going to start off on that.
Sure, happy to. Okay, the first rule of any mediation, as everybody knows, is making sure you have the right people in the room. And, many of the mediation rules that you see around the country have requirements that you must have a party representative with authority to settle to be in the room. The problem is there are a lot of cases where there are external influences or impacts that play out very meaningfully in whether a settlement can be reached and how it can be reached. The quickest two, as you see on your slide, to think about are indemnity insurance. But I've spent some time mediating both as a mediator and as a party in some breach of fiduciary duty actions where either a creditors committee or a liquidating trust from a bankrupt estate has filed an action alleging some sort of breach of fiduciary duty against former officers and directors. And they're not looking to those folks to pay the settlement and create a recovery. They're looking at the pot of gold at the end of the rainbow called D&O insurance. And it's important to make sure that you've got the people who actually are going to have to stroke the check in the room at the mediation. And so the point is make sure you don't have just the folks, who appear in the caption, but the folks who have a meaningful role or a meaningful impact on whether a settlement can reach, how it's going to be funded, et cetera. So those are very important considerations. As you think about how mediations impact third parties, you also have to think about what happens in a mediation where you've got multiple defendants. And in particular, this comes up often in sort of joint tortfeasor sort of cases where you've got a range of parties as defendants who may both have defenses to their liability to the plaintiff, but also claims and thoughts about contribution between and among each other. And so these are things that go into a lot of detail, and there's, frankly, you could do a seminar or even a day probably talking about some of these things, but the one that comes to my mind very quickly that I've run into in mediations is the notion of a contribution bar, where you may have 3 or 4 defendants in a mediation, and 2 of them are ready to cut a deal. and willing to cut a deal and want to cut it right there, but they want to make sure that they're done, and that if some other non-settling defendant leaves the mediation without having agreed to settle the case, that ultimately later gets sued, that those settling defendants aren't pulled back into the litigation through some sort of third-party claim or a cross-claim or what have you. And so you need to think about that. And the notion of contribution bars comes up in most of those scenarios. And depending on what court you're in, some courts are more or less willing, to sign or approve a settlement agreement that's got a contribution bar in it. So those are a couple of things to think about as you move into a more complex settlement with multi-party ideas as well. I know, Jeff, you have a couple of thoughts on this.
Yeah, just that it's, there's certain lawyers out there who full-time practice insurance or subrogation or indemnity rights. It's such a complicated field. I ran across one case, a very simple fact pattern, which is why I'm just going to run over it real quick, that I thought kind of talked about how difficult this area can be. It was a plaintiff in a tort case who settled with a defendant insurance company. They reached a settlement agreement at mediation, and thereafter the insurance company cut the check to the plaintiff, but the policy was issued jointly in the name of the plaintiff and his spouse. So the insurance company cut the check to both the plaintiff and the spouse, like they frequently do. They treat the policies as being, written, the title is written in gold. And the plaintiff wrote back and said, well, I'm estranged from my wife now. That check needs to be written to me. And the insurance company said, no, it's based on who the policy was in. And, it's really tough to see that you could have seen that issue, but it's why we just flag it. And there's issues like that in fiduciary duty cases and construction cases and all across the way. And my final thought on that is that I really do enjoy now in federal practice the mediators who set up a call before mediation, maybe a day or two ahead, to just talk over the fact pattern. It's very proactive. It helps me think about the case. I've got a busy practice in multiple cases, and sitting down and having to present to the mediator sometimes can help you catch that errant issue that's buried in the facts. And that's really all I have to say, that's something that, as a practicing lawyer, you hope either you or the mediator can spot that before you walk in the door.
Okay. So I think we want to move on now to documenting the settlement. And we'll start by talking about what we're doing in the case of the complex settlement. So let's start by being clear when we talk about the complex settlement agreement. To be clear when you're drafting, whether you're doing a term sheet that's going to be binding and later there'll be a formal agreement written with all the bells and whistles, or be clear that these are the terms we've agreed upon, but that there's no definite settlement, and it will not be enforceable until it's in a form that's written and is acceptable to all parties and signed by all parties. So when you have a complex settlement, you're doing one of the two things: a pretty full term sheet that's going to be binding, but we got a lot more drafting to do, or a pretty clear term sheet, but we got more drafting and we don't have a deal until all that drafting is done. So knowing which one you're doing, I would say when you've got the complex settlement, if you're going to go and draft afterwards, continue the mediation through the documentation process. Try to put some time limits on it, put responsible parties on it, but keep the mediation open, because once you've closed that mediation, then you have reporting requirements to the court at the conclusion of the mediation. I personally as a mediator, never close the mediation until I have a document that is something that is binding on the parties. If they're willing to be bound by the less detailed term sheet, that's fine. But if they're not, that mediation is going to stay open. It's going to be continued. The next thing is, if we're doing a term sheet, whether it's to be binding or to be subsequently documented, put in all those essential terms in as much detail as you possibly can, anticipate the other issues that are going to come up, and set a deadline for getting the agreement completed. I can tell you from experience that setting a deadline doesn't always help if parties aren't cooperating, but you should try that. Be sure you've got drafting responsibilities and you know all the different parties that have to approve it, because sometimes you've got two parties who are really the active parties, but you've got two other parties who are ancillary parties, and they still have a right to approve even though they're not actively involved in the drafting process. Also, during drafting, in my experience in these complex cases, more disputes are going to come up. So include a mechanism to resolve disputes that arise during drafting. And I encourage this to be done whether you're even if you have done a term sheet that has complete terms and all parties have agreed to, subject to the preparation of the formal agreement. In that, I include the mechanism for resolving any issues that arise related to the final agreement during the drafting process. And then go back, whichever you're doing, be very clear about whether what you've done is binding or not binding. Once we have a settlement done, a lot of the litigation that arises, aside from the settlement itself, interpreting the settlement and whether people really intended to be bound, comes when people come in later and want to change or add to and refer back, but in the mediation he said this and I expected that. So that's a big pitfall that can get us back in court. And Jeff, you're going to talk about that, I think.
Yeah, once, unfortunately, that there's a disagreement and it slides into the parties bickering about whether or not there was agreement. And yeah, both you, Derek, and Judy have highlighted that the slope gets, steeper and steeper and more slippery when you have multiple parties and you have, indemnity issues. I thought I would just add a little color to this presentation to let you know, typically the friction issue is that, number one, and you can see this on your highlight, in the Ninth Circuit at least, the court looks to see if it's a federal cause of action that a federal rule applies, or are there state causes of action, so some state rules should apply for confidentiality. Because you have the general rule that I talked about earlier, which is discussions in mediation are supposed to be privileged, and they're not supposed to be admissible in evidence. And there is no uniform federal rule on confidentiality in mediation within the federal courts. We do have Evidence Code 501, which is the privilege in general. And it's on your handout, and as you can see, it's pretty general. There's a very notable disparity in the approach and scope of what gets into evidence in a dispute between parties trying to determine or evidence to the court that there was intent to be bound or not. And it goes two roads. One, if it goes the road of the federal rules of evidence 501, it has a better chance of getting those discussions into evidence. If it goes to state law privilege, it's pretty much not going to get into evidence. That's just from my review of the cases. And I highlighted a couple to just talk about quick. And we have the Wilcox versus Arpaio case in the Ninth Circuit. The site's on the handout. That's Joe Arpaio from our sheriff in Arizona. In that case, if you read it, talks about, just to give you a backdrop of what it was, the plaintiffs were county advisors or supervisors and officials who claimed that Sheriff Joe Arpaio and company retaliated against them for speaking out about what he was doing was wrong. The county realized that, wow, this is going to be a huge issue of litigation, that there's probably 100 people out there that could come forward and could sue us. So they set up a dispute resolution program before a retired judge, and a couple county supervisors come in and they settle a case for just under $1 million. And later on, after the mediation, the county decides that they don't want to be bound, and they balk at enforcing it. And there is a fight that breaks out then about whether or not what was agreed to could be introduced into evidence or not. And that basically, that dispute is, in the Ninth Circuit, was a determination of whether Arizona law governs or the federal law governs. And the Ninth Circuit interpreted and actually had emails from the mediator, and essentially the federal rules allowed it, and it governed. And they found that there was sufficient agreement and that there was a settlement. And after the Wilcox versus Arpaio case came in race Sony Computer Entertainment versus Handstar Display, which is also on your handout, the site. And it follows up, and it also talks about the friction between the federal rules and the state rules. Another situation in which a mediator proposed to the parties that the matter be settled, and it was subject to execution of appropriate settlement agreements, and it was a double-blind situation in which the mediator gave both parties, said, look, just respond to me. Either you accept it or you reject it. You don't have to know. The other side doesn't have to know. And both parties accepted it, and you thought you had an agreement, and that all of a sudden ends up into litigation, and the case was reversed. The courts talk about the federal and the state claims and what's admissible and what's not admissible, and there you get a good view of one state's, that being California's, rules on what they think about trying to introduce confidential mediation communications. That court talks about California, and I've also put that in the highlights. California has a pretty, straightforward thing, which basically says communications and writings made for the purposes of, in the course of, and pursuant to a mediation are not admissible. They're not subject to discovery. It applies to written, it applies to oral, it's tough. And so that's the rub that exists out there, and it's a legal quagmire that hangs out to lawyers and people who are unfortunate enough to walk out of a mediation and have some type of an agreement that's, either, it's not clear that they're going to do it later, or if they have a complete agreement, and it's an invitation for a lot of litigation down the road. And basically what you're doing is you're asking the court to step in and to be part of the mediation. And most state courts, most state and actually the local bankruptcy rules and the district court rules evidence that the courts don't want to do that. Derek,
my experience is that most judges would much rather preside over a trial on the merits of the substantive issue at hand than wade into the he said, she said, and often sort of ad hominem stuff that comes in when you start talking about, well, we had a deal, and the other side says, no, we didn't, but you said this and you said that, and they really don't want to get into that. There's no question. I look at the rule in Delaware, in particular, because that's where I do most of what I do, and there the court has very strict rules about confidentiality and the fact that even the mediator is effectively immune from discovery, can't be compelled to testify about that, about what happened in the mediation. So really do everything you can to avoid some sort of after the fact, did we have a deal, did we not have a deal, and what are the terms of it?
Have you ever been, as a mediator, had anyone attempt to take evidence from you? Same with you, Judy. My experience is I have not.
Me either.
Well,
and
funny,
part of that is because, I was going to say part of that is because as a mediator, I bring a detailed confidentiality agreement to every mediation, and I've sent it out to the parties' counsel ahead of time, and it's a condition of my serving as a mediator, and part of that prohibits them from making an attempt to bring me in. Go ahead.
Yeah, it's funny
Eric.
you asked, Jeff. I have not had anybody try to do it to me while I've been a mediator, but I have been in a couple of cases where people tried to get discovery from a mediator, and the court, as you would expect from the rules, said no. But I've had a slightly different issue, which is interesting to think about. I was a party in a mediation once. I thought we had a deal. We didn't leave with a signed document. We left with an email from the mediator to counsel for the two parties, indicating agreement on a set of 4 or 5 specific terms. And later, one of the parties determined or took the position that no agreement had been reached. And I didn't actually go try to take discovery, but I was stuck with what could have been a busted deal and had to actually file that dreaded motion to enforce the settlement agreement reached. I was lucky in that case. I asked the court to instruct the mediator to file a more comprehensive report of the mediation, because usually a mediator is obligated only, and in some cases restricted very carefully, to filing a report that says the matter was settled or the matter wasn't settled. Here I was fortunate enough to get the court to instruct the mediator to file a slightly broader statement that actually set forth the material terms of the deal in a report that was filed with the court. Strangely enough, once that happened, the other side decided, yeah, maybe in fact they had reached a deal. So you do want to stay away from that, but never had discovery taken from me and hope not to.
Yeah, in the state court in California, there's case law littered around that basically states that the mediation confidentiality statutes provide no exception for judicial estoppel, and the courts may not fashion one, except unless you're going to contest jurisdiction. And I just took away from that, which is, just states, again, not wanting to wade into this area of whether parties cut a deal. And probably that's enough. We're not going to have any more time to talk about that anymore. Judy, you want to move on to just talking about the Scrivener?
Sure. I will lay something out before I do this, and I'll tell you what my bias is. My bias is mediators shouldn't draft agreements. But having said that, I'll try to be more balanced. I will say more than a lot. Many of the state rules that I've found, the rules governing mediation, go into a lot of detail about how careful a drafting mediator must be to only record what he or she's been told and not insert any of the mediator's thoughts or cautions into the drafting. And the reason for all of that is that the drafting of an agreement, by definition, is a legal process. It's not a neutral function. You can decide how to word something, and there are consequences for how you choose to word it. You can choose to include something or leave out something, and that can have an impact on the parties down the road. In North Carolina, we are close to being prohibited from drafting mediation agreements. It's certainly discouraged in every mediation CLE I go to. But on the other hand, universally, as we've already talked about, all the rules are requiring that there be a written agreement. It's interesting, in Florida, they say that part of the mediator's responsibilities is to ensure that all the mediation rules are complied with, and one of the mediation rules says that there has to be a written statement. So now the mediator is responsible for making sure there's a written statement, and then the Florida rule goes on to say, however, the mediator is not required to write the settlement. I will admit that in most, but not all jurisdictions, it's permissible for the mediator to serve as the scrivener. But scrivener is the word, and scrivener means writing down what somebody tells me to write down or typing up what they've outlined. But here's where the real rub is. And if you happen to be a mediator in a case where one or more parties are pro se, you're really about to get in trouble, because with two pro se parties, these people don't know how, most likely, to write a good, enforceable settlement agreement. And in every set of mediation rules I've read, they have specific provisions regarding pro se and specific requirements about disclosures that have to be done in writing, signed by the parties, showing the mediator that the parties represent. The mediator is not representing either party, can't give advice, is not serving as a lawyer. In one state's rules I read said that if the parties want the mediator to draft the agreement, they have to sign a separate document to that effect, and both of them have to sign. Some states also require, and some urge, that the mediator dealing with pro se parties require or urge the parties to have an attorney review the document before they sign. Well, it makes no sense to me, because if they had an attorney, the attorney would probably have been at the mediation with them. And at the very least, sending them out to find an attorney to review it, at the very least, it's going to delay the process. And most of the attorneys I know are going to raise a whole bunch of new issues, and we're going to be starting all over. So you need to be really, really, really careful that you're not practicing law generally when you're documenting things, and certainly when you're working with pro se attorneys. I looked at a couple. I looked at Maine professional ethics rule authorizes the mediator to draft a settlement agreement on behalf of unrepresented parties, but then he must advise and encourage any party represented by independent counsel to consult with that counsel, and any unrepresented party to seek independent legal advice before executing it. In Massachusetts, I read a lot of stuff, and generally what I took out of it is that mediators should refrain from giving legal advice and drafting settlement agreements, and that's more broadly. Only help the parties identify and analyze the issues. And then in the case of pro se, it says that you're risking conflicts of interest, practice of law in terms of advising them, and it raises lots of ethical concerns. So clearly, the best practice is for the parties' counsel during the mediation to draft the memorandum of agreement, capture all the key points, and if a dispute arises, then the mediator can mediate the dispute, but shouldn't be suggesting the language. And of course, the parties sign the mediation. In some states, I know the attorneys sign also. In some states, if an attorney signs without the party, it's not binding. And the last point to make is we still have some non-attorney mediators out there, and I don't know if they're in on the lines, and they do a great job in mediating, but they absolutely cannot draft the agreement, because under most any state bar, the practice of law includes preparing a contract, and a settlement agreement certainly is a contract. So we're getting close to running out of time, and I want to leave time for questions. But Derek, did you have anything, or Jeff, to add on this subject?
This is Derek. I don't.
Okay.
And I do not. I do not either.
Okay, so we still have. I tried to rush through that. So if we have any questions, and let me figure out how we figure out if we have any questions before we come back to our conclusion. Let me see if I see any questions. Well, okay. Unless I'm misunderstanding, I don't see that we got any questions. So maybe that means we answered everything. So we'll go back to our conclusion. If you've got a question, send it in. So the conclusion is, go ahead.
No, I think the questions are going to ABI, so we probably wouldn't see them. So why don't you just hit our conclusion, and then ABI can let us know.
Okay. Well, we've talked about this, that you always have to know what rules you're under. Local rules, bankruptcy court rules, and also not just the rules, but the order that puts you in place if, in fact, there is an order. And the importance at the end of the day, I think Jeff made that point, that you're tired, you're ready to go home, but you've got to spend the time to get everything nailed down, and you've got to be sure you get the signatures of the parties. And looking at all the hot spots that we outlined so that you don't fall into any of those traps, whether it's binding third parties or giving advice in the drafting of the agreement that puts you representing a party. Also, looking at whether you have both intent and definite terms that cover everything that is expected of the party. The terms are definite enough that a court can enforce it in the event of a breach. And let me let Jeff and Derek add any other thoughts.
Yeah, Jeff here. You know, one thing just from a litigator's perspective now, since I'm not mediating on federal court, realize that when we say that there's local rules and there's local bankruptcy rules and district court rules that govern mediation, that it's not simply rules that might talk about the mediation process. There may be rules that you have to satisfy before mediation, deadlines that you can get in trouble with the court. I was recently in the Eastern District of New York. Counsel and I had picked out a mediator, and when I was, documenting and trying to get everything squared away, I realized the Eastern District of New York Bankruptcy Court has a rule that you have to submit a declaration or affidavit of disinterestedness by the mediator to the court. Some jurisdictions you have to file and identify who the mediator is and file it with the court beforehand. So, there's things to tickle on your calendar out before you go to the mediation, and I just put those all under one big general heading, which is now when I go to mediation or get ready to go to mediation, I take the time to pull up the local district court rules or the local bankruptcy court rules.
Absolutely, and let me add another one. As I was preparing for this, I saw one area where if you were going to serve as a mediator in that state and you weren't licensed to practice, you had to file a document with the court indicating that you had spent at least, and I think it was 5 or 6 hours, reviewing the procedures of that court. And I thought, oh boy, I'm glad I haven't ever done one in that state because I hadn't noticed that before. But absolutely, always read the applicable rules before you get there. Derek?
My only final parting shot is, my experience both as a party and as a mediator is what I sort of view as the corollary to you spend all the money in your pocket when you walk into a bar rule, which is parties only ever get to agreement when there is a time limit or you're at the end of the day or what have you. And oftentimes you spent a lot of effort and time getting there. And once they finally reach agreement, people want to think they're done and go jump in their cars or jump on their planes and get home. And it really does pay huge dividends and avoids enormous problems if you force parties to be disciplined and actually get this writing done before they leave the room. It's painful at the time, but in hindsight, it's well worth the effort. And that's my last comment.
All right, back to ABI. Thank you.